Hi everybody, I hope you're all well. My name is Jen. I make videos about the law, and today I'm talking about the Fe1 Criminal, and we're going through the Fe1 Autumn 2023 exam. So the first question was a problem question. You're advising Kevin. So he was actually with somebody else in a bar, and there seems to be a fight broke out, self-defense, and the prosecution is claiming the force used was not reasonable. They claim an attack was not imminent and that David had no record of violence, advised Kevin. He's saying here that he thought he was going to be killed and was frightened for his life. So I don't see the murder thing. I definitely see possible manslaughter here. Or even assault causing serious harm, even though the stab wound to the neck was what ultimately killed David. Also drinking, so possible defenses of intoxication. We already mentioned self-defense. So yeah, I would argue here that it was more akin to manslaughter than murder, just because of our self-defense pieces here. Because they were going to argue, and we don't really know the backstory about how violent this other person was. It's also arguable, that he didn't know the fatal blow, which was the one to the neck, was going to be the one that killed him. But we can also argue that it was a total loss of control from Kevin, but we might argue there that it was the intoxication that led to the total loss of control. So yeah, I would say definitely would be reduced from murder to manslaughter, just given the facts of the case. Question 2 then is a problem question, where you have to classify the criminal offences in terms of summary and indictable offence. I think that's a fairly straightforward question that most people would have been able to do. Question 3, if we read down to the end, you're asked to advise. So to determine if there are relevant grounds for overturning this conviction, you are now asked to advise James on all 3 directions as they relate to the issue of consent, the mens rea for rape with regard to recklessness, and the presumption of innocence. So what we assume here, there's a conviction of rape, and a sentence of 6-year imprisonment, and then there's a direction to the jury. There's 3 different ones here. A complainant who is intoxicated cannot in law consent to a sexual act. In cases where there's a high level of intoxication but no evidence of verbal communication of consent, this will constitute evidence of lack of consent, particularly where the complainant claims that she would not have consented if she was sober. So I definitely think here that if you look at Section 9 of the 1990 Act as amended, that provides that consent of 2 people of the right age, requisite mental capacity, have voluntary sex. If a woman's not in a position to give consent, there is no consent. And this has been held in a number of cases. Consent can be withdrawn at any time, before, during, or after the act. And if one continues, then you have the required mens rea. But of course, there is defences available where the defendant honestly believed the intercourse was consensual and there was no rape. This is, of course, subjective. Second direction, as a matter of law, if a person drunkenly had sex with an intoxicated woman, that constitutes a reckless requirement for offensive rape. In terms of any mental state that is required, the question here is, was the complainant drunk, and did the act of sexual penetration occur at the time she alleges? So let's look at that piece to whether consent had been withdrawn, and a defense of intoxication would assist you but it would only apply if he was reckless as to whether she consented or not. So then the question is he mistakenly believing she consented? If he did, then he cannot have been held to have the mens rea for rape. And then the final piece is the presumption of innocence, which is a fundamental right. But when it is applied to the area of rape, we are looking at the Section 3 of the Criminal Law Act 2006, which provides for a reversal of the burden of proof. It is for the defendant to prove that he honestly believed the girl was 17 at the time, was older and of age to consent to sexual intercourse. And of course, in the criminal standards, this is beyond reasonable doubt. But anyway, the presumption of innocence is very important, which includes the requirement to prove something beyond a reasonable doubt. That means if you have a balancing exercise in that respect, this is direction 3, by the way, where it's equal, you would have to give the benefit of the doubt in the circumstance of the accused. So it's a 50-50 situation as to the issue of consent. If you really want to go into figures, you have to give the benefit of the doubt to the accused person. Now, that's the best way I can explain it to you. That beyond a reasonable doubt is more like 75%. I don't think it's 50-50. Because if I think of like balance of probabilities would be 51%. So beyond reasonable doubt would have to mean that it's more than a 50% belief, I think. Because the stakes are higher, you know. So no, I disagree. I disagree with the direction here. I don't think it was well explained to the jury. Question 4 is a problem question. People who meet, they're 19, so they are adults, albeit young adults. They light a fire outside a clubhouse to frighten parents and children after the disco starts. Liam, who has developmental or intellectual difficulties resulting in delayed cognitive development, which restricts his ability to monitor and control his behaviour. Let's do it. That may be a defence. Next morning, they were hungover. Next morning, Dan woke up. He decided not to participate. He tried to call Liam, couldn't reach him. Liam brought the tires and the petrol to the clubhouse. Jim accompanied him, but other than that, did not assist. So this is kind of like common design, joint enterprise, accomplice, accessory to the fact. Having an intellectual disability, there's arson here, damage to property and endangerment to the children. And you have to advise Dan, Liam and Jim of their possible criminal liability. Question 5 then is a problem question about Robert. You have to advise him on his problem question. It seems here to be stealing, so theft. So they basically steal stuff from Lidl. He actually got a heart attack as well, but the causation of the heart attack was from level obesity, putting increased pressure on the heart from running from the shop. So that would be the eggshell. So yeah, quite interesting. Murder, manslaughter as well. Bit of dangerous driving. So the eggshell would apply as regards the causation. Okay, question 6 then is a quote from DPP v Klobakowski as regards the defence of duress. It's actually quite a nice quote and quite a nice case that I'm actually going to include in my ebook. And it says, the defence of duress may apply where an individual feels under a compulsion to commit an offence as a result of threats made to him or another person. The person will, of course, have the necessary mens rea, but his will is overborne by virtue of the threats made to him, and so he commits the offence. There are 3 aspects. The first is that the threat must be of death or serious harm. It's quite a high standard. Second, the threat must be immediacy. And third, those threats must be so great so as to overbear the resistance of the person to whom they are made. It's actually quite a nice quote around duress. Okay, everybody, continuing on. So Kevin is 13, so this is advising, this is infancy as a defense, I guess. There is horseplay with a female, which would be deemed sexual harassment. He also threatens her. Kevin also threatens Amy. Amy, that he would stab her in the face until she died, which is massive threat. She's terrified. Then he was harassing her on Instagram and Snapchat. She blocked him. Then he started appearing outside her school, causing her huge distress. And she has told her parents. Now they have contacted the guards. So this is classic sexual assault, harassment, like RV Ireland. Then I would say stalking. This was put under section 22 of the criminal law, miscellaneous provisions. He also made a threat to kill. Then the defence of infancy here would also come under section 52 of the Children's Act 2001. Okay, we're nearly there. So we're on question 8, which is 4 problem questions you have to advise the DPP on. Ranging from different issues. So the first one is around the Gardaí hearing a number of complaints, and here there is a suspicion that one person has been a burglar, and you have to advise the Gardaí, the DPP, as to the charges you can bring. So here this would be a burglary. The second one then is serving a sentence for aggravated burglary. Lawrence was convicted. For other offences relating to assault causing harm and a robbery, he was remanded in custody and produced before the circuit court. He dislikes lawyers and judges. During the sentence hearing, he threw a Bible at the sentencing judge. So this would come down to like contempt, for example, and some public order offence because he said some, obscenities. The next question then is around seems to be manipulating or altering business records, which would be under the 2001 Act. It's also known as false or deceptive behaviour, dishonesty under section 2, false accounting section 10, and then the final one then is around assault causing harm with the defence of consent. This regards sport. So you have the definition of assault under section 2, section 3 assault causing harm, and section 4, which is your assault causing serious harm. And then obviously you have the consent issue because this is sport, organised sport. And that was it. I thought it was actually a fine criminal law exam. I think people who knew the bits around the 2023 Act and the barring order, and that applying to when you're not in a intimate relationship, or around the stalking piece, definitely would have got kudos for that. But yeah, other than that, it was a fine exam, and thank you very much for watching, and I'll see you in the next one.